Madam Deputy Registrar, would you please call the matter?
Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Belize, hearing of appeal in CCJ Appeal BZCR number 1 of 2023 between Nevis Betancourt and the King. The members of this morning's panel are Mr. Justice Anderson, presiding judge, Madam Justice Rajnath Lee, Mr. Justice Barrow, Mr. Justice Burgess, and Mr. Justice Jamadar. May we have the appearances, please? Thank you.
Your Honor, I am and I appear on behalf I am reading this tribunal, this announcing, and we are instructed by the chief.
Thank you, Mr. Prasad.
Please, Your Honor, Sherilyn Vidal, Senior Counsel, Director of Public Prosecutions, with Mrs. Jacqueline Cheeseman for the respondent crown.
Thank you, Mrs. Vidal. So welcome, Counsel. We're about to begin the proceedings for this morning, but before that, I would like to take the opportunity to welcome the very impressive gathering we have on our left, students from the Hugh Wooding Law School, and I gather we will be joined by students from the St. Augustine Law Faculty. You're very welcome, and we hope you find these proceedings interesting. Is there any other housekeeping matter that we need to engage in, Counsel?
Not on this side, Your Honor.
Thank you. In that event, we are ready for you, Mr. Prasad, to present. You have it. Thank you.
Much obliged. Your Honors, this appeal, as the court well appreciates, comes out of the Belize jurisdiction and relates to a conviction for murder. And what we propose to do is to take the court through very briefly the arguments that we have put forward. The court should have before it submissions on behalf of the appellant, and there should also be before the court responses from my friend on the other side, the learned DPP, as well as a reply from the appellant, and yes, and a very brief speaking note, for which I apologize for only putting before the court.
What's the explanation for that? I was quite concerned by it, that you should file it this morning.
Well, as I say, I do apologize. You know, it is something that I would usually do for the assistance of the court, my unfamiliarity with the jurisdiction, but I did try just to make it very brief, because as the court would appreciate, when you're preparing the appeal and, sometimes it's helpful to just articulate things. It's there to assist. I do apologize if it's the court, does not find that filing it at that point. I certainly could understand why the court would raise that, but I do apologize.
I can see what you're understanding, since even now, copies are being printed for some of my brothers who have not had a chance to yet print. So it really upsets things. I don't know if the DPP has had the opportunity of seeing them and reviewing them. Certainly she would not have had the opportunity of responding to them, but anyway. You have apologized, and I guess we will not crucify you.
Yeah, well, I appreciate that approach, but I will, hopefully in future times, I will make sure that doesn't happen.
And we note, Counsel, correct me if I'm wrong, that this is your first appearance before this court.
I would like to get everything right, but...
And as my brother to my left suggested, it is customary, if speaking notes are to be submitted, that they are submitted earlier. But given your novelty to the process, we will proceed. Thank you.
Thank you. So, Your Honors, I started by saying, just making sure that we have all the documents, the speaking note, and that is the totality of the material outside of the record of appeal. Virtually, what I propose to do is to just dive straight into the submissions. This was a case, and, you know, I take the approach that essentially it was a case where the learned trial judge, having considered the evidence, considered the defense, the defense put forward by Mr. Betancourt, and rejected it, as she was certainly entitled to do. What we say, having rejected the defense, the learned trial judge is obviously required to go back to the prosecution case and to look at it and to ensure that this appropriate standard of proof has been met.
Which she did. She went back to the prosecution's case.
Did go back,
Yes.
and she was sure in relation to the issues that she felt was appropriate. Where we take issue is that having reviewed the evidence, we take a different view from the learned trial judge. We felt that there was evidence that when one looked at it was sufficient to raise self-defense on the prosecution's case. What I propose to do this morning is to take the court through the particular pieces of evidence that we say was sufficient to raise that issue. It's in the submissions, etc., but I will take the court through and then juxtapose that next to how the learned trial judge dealt with the question of analysis of self-defense arising on the prosecution case. And what we say with the greatest respect to the learned trial judge is that we felt that she did not show a proper appreciation of the material facts. We also lay some criticism that the learned trial judge may not have appreciated the totality of the evidence, and that would have contextualized the evidence in a particular way. As a consequence of her assessment of the evidence, her view of the evidence, she took a particular view where she said she didn't see any basis to say that the appellant would have had an honest or reasonable belief that he was under attack on the prosecution's case. I have to distinguish that. And that is something we take issue with. So essentially the approach is to start by taking this court to the evidence that we think is material, having gone through that, to take the court, of course, to what the learned trial judge said, and then having gone through that exercise to just make some observations on how we say certain fundamental legal principles in criminal trials were engaged, and that essentially we will make observations that certainly in relation to the trial judge's approaches to the evidence and to the legal principles, she may have fallen short of what is required.
Okay, well, I think counsel, we agree you have laid the wicket, to use a cricketing analogy, quite well. So we're now waiting for you to go through the evidence as you have promised us, please.
Certainly. Thank you, Your Honor. So might I first refer the court to the evidence of Mr. Ramirez. This was the main witness, and we can find Mr. Ramirez's evidence on the record of appeal. It starts at page 68 of 386. I will attempt to summarize and then refer the court to material parts. So Mr. Ramirez, who I want to describe as the only IC witness of the actual shooting, put it in that context, in examination in chief, starts by giving evidence that the appellant shoots the deceased Mr. Canales while he's sitting in the chair. Now, if that was the total state of the evidence, I could not be here. I could not take issue with that. But what we found interesting was that under cross-examination, when Mr. Ramirez was cross-examined, a question was put to him. This is at page 78 of 386 of the Record of Appeal. And I don't know if I want to use the word amplified or clarified, but the cross-examination had the effect. And I'm going to read, my lords, I'm reading from line 9. So he was standing up when he got shot? Answer, yes, he was standing up. Question, and it was when he was going with the machete in his hand, that is when he got shot? Answer, he was shot before that. He was shot before when he got 2 shots to his chest area. Question, Chile is the deceased, it's the nickname for Castellanos. Chile got 2 shots and then he raised the machete to chop the young man. That's the question being posed. The answer, it was when he raised the machete to attack the young man that he was shot 2 times, and then he turned around, he went down the stairs and he continued shooting. So from that cross-examination, you get the impression from the witness that the shot was fired not while the gentleman was sitting, but while he was standing up with the machete in his hand upraised. Now, that we say is a material piece of evidence.
Sorry, that these 2 shots
That these 2 shots,
were shot when he was standing up.
yes,
Does it say anything about other shots being shot into the deceased before he was standing up?
at this point, no, please.
At this point, no.
At this
Okay.
point, no, Your Honor.
Okay.
But it sets the foundation, if I may put it this way, to say that the evidence coming from the main IC witness was that the 2 initial shots, I have to accept his initial shots, 2 initial shots were fired when the gentleman was standing up.
Sorry, could you go back to where you had us before and show me the word initial?
Sorry, it was when he raised the machete to attack the young man that he was shot 2 times and he turned around and went down the stairs.
Can it go back up a little?
Yes,
We're
certainly.
not seeing it on the screen. It
Oh,
needs
I'm
to-
sorry. Oh,
No,
yes,
no.
that's,
Mr. Fasad, let me tell you,
Thank you.
Your Honor.
my understanding of your thesis is that there were 3 versions of events. Your submission is that the judge captured 2, but the judge did not address the 3rd version.
Yes.
The 3rd version is what you have drawn to our attention.
Yes, Your Honor.
Now, what has engaged me, and I really do need your assistance,
Of course.
what is stated in that particular answer, which remarkably is in italics as indicating that this is from the judge's notes. Yeah?
Yes.
So this is not the transcription, but this is from the judge's notes. Mr. Ramirez, as one understands it, is a Spanish-speaking witness.
Agreed.
He was using a translator. Yeah? Let me tell you why all of this
Yes.
is significant to me. There are, before this instance, 5 instances, and I made it my business to count them,
Yes.
in which the sequence stated by Ramirez is very clearly drawn firearm, shooting, machete drawn, chopping occurs, more shots. 5 instances. Would you like me to go and find them for you?
I am happy
No.
to take the...
You know them very well.
Yes, yes.
Therefore, it is in this 6th instance based upon the judge's rendering of what she heard, that you are relying on a third version. The thing is, Counsel, the third version, as you choose to call it, is part of the version of events given by the same witness. So it cannot be, and I think you will agree with the logic, that the two versions from the same witness are correct or accurate. One stated 5 times,
Yes.
and one stated 1 time. How are we to regard this?
Well, Your Honor, if it is, in fact, and I have to accept what the court is saying to me, that there are on the evidence in chief of Mr. Ramirez and in cross, I want to use the word inconsistent because both can't be correct as
Right.
both can't be correct, then in the normal course of things, then you would expect counsel to accept that there is an inconsistency and certain things will follow.
Sorry, which counsel to accept?
Well, the counsel who is dealing, well, I certainly think in this case the defense counsel would not have, this would have been the answer favorable to the defense counsel.
Right.
So I could hardly see the defense counsel wanting to put it as an inconsistency. He would have elicited evidence that was favorable to his case, and when he got
Right.
the answer, he kept the answer.
And here we have, as the Belizean counsel president will tell you,
Yes.
extremely accomplished defense counsel, Mr. Richard Dickey Bradley.
Yes.
And he gets this answer. And what does Mr. Bradley do? Drop it.
Yeah.
That's the answer I want.
Yes.
So he does not ask, okay, you are now saying he chopped before he was shot. This contradicts your earlier answers. Would you say which is correct? Bradley doesn't do that. He leaves it there so that when the transcript comes out, there is a nugget for you.
As he's
I notice this is not raised
Yes.
in a court of appeal, is it?
Not that I'm aware.
Right.
Yeah.
So it is just a nugget for you, 1 out of 6. Yeah? So I'm telling you my great difficulty in giving any weight to it. But you can persuade me that I should.
And Your Honor, my instinctive, I mean, as I say, I'm thinking off the top of my head here, is that this comes on to a question of the trial judge, how the trial judge also seeks to deal with the evidence. As the court quite properly points out, 5 versions, 1 version, but can we say that the learned trial judge, when it came to the evidence, showed an appreciation for the inconsistency, if I could put it that way? Did the trial judge, in her analysis in relation to self-defense, say there are 2 versions on Mr. Ramirez's evidence? Because I will politely submit that on the version that defense counsel got out of the witness, we say that that answer was capable of raising self-defense on that answer alone. I do not dispute.
I fully accept that.
Yeah, I do not dispute that if there were 5 other answers that did not raise it, it was for the trial judge, as in a judge-alone trial, to show at least an appreciation of the salient facts, evidence, and to show analysis. What I would have expected, with the greatest respect to the trial judge, was that the trial judge would have once acknowledged that there is this evidence, and she did refer to it in her analysis of the evidence, but that she would...
Sorry, the trial judge referred to this particular bit?
The fact that at one point in her summation, she, and I'll take the court,
Please do.
the trial judge talked about, I thought through the possibility that when when the appellant was approaching, the gentleman got up and raised the machete, etc. So the trial judge does consider that scenario.
No.
Sorry.
I want you to show me where the trial judge considered this statement.
Okay. Well, can I take you there
Please
now?
do.
Please, yes.
Yeah.
Mr. Prasad, while you're finding that, at some point you'll tell us, I imagine, the consequence, if this is an inconsistent statement on Ramirez's evidence, whether it's 1 in 5 or whatever, and if there was a duty of the trial judge to deal with it, of course, what's important for us is what could be the consequences
Yes.
in the totality, right?
Yes.
So you'll get us there eventually, I think, in your part 3 of what you say.
Yes.
That is your comments overall. For now, we're on the evidence and the record, yeah?
Thank you, Your Honor. I will certainly do that.
Yeah.
Can I direct Your Honors to page 335 of the record? 335?
That's 335 of 386?
That is correct?
Okay.
Is the judgment of the trial judge?
Yes. Yes, please. And
If you give us the paragraph, that might help, because
Yes,
some of
I'm-
us have a
I'm going
different.
to do it in the old way,
page
6 slides from
number.
the bottom. So,
What paragraph?
I must say that my record doesn't have paragraphs. It has line numbers. So it would be about from line 18. It starts, I have considered.
Yes, we're having problems finding it. So maybe you could just read it for us. We
I
have
am
it on screen.
certainly.
Yes.
In answer to the court seeking, I have considered that the accused may have approached the deceased as he sat, and that the deceased rose with the machete and put the accused in fear, resulting in him shooting the deceased.
Mr. Prasad, can I say that that is paragraph 46 of what we have as a written judgment?
I'm grateful.
Yes, thank you.
So,
Have you finished?
and I'd just like to read on
Yes.
to the next 4 lines. However, I have looked at every possible sequence of events, cannot find evidence to support this or any other version of the accused of what happened that night. And I have to say I had highlighted that because I wanted to make a complaint, because it seemed to me that what the learned trial judge at that particular piece of analysis was acknowledging what was said by Ramirez in his answer in 6. So that's how I saw it, and it was essentially that I've considered that the accused may have approached the deceased as he sat, and the deceased arose with the machete and put the accused in fear, resulting in him shooting the deceased. I'm going to juxtapose that next to what Mr. Ramirez said and I had just read to you, but it was in that context I took the view that the trial judge was looking at that possibility.
You're shifting me from the question which we were dealing with,
Yes?
which is the testimony of Ramirez that Chele chopped before he was shot.
Sorry, no, Chile chopped before he was shot.
Yeah.
No, that's not our case. That's not what we understand.
No, that's the third version.
No, sorry, with the greatest respect, allow me to just indicate what we understand the version to be. We are saying on cross-examination that the witness Ramirez said that what he saw was the firing, or what he heard or what he saw was the firing of the shots when the deceased got up and held the machete up in his hand. Full stop at that point.
It was when he raised the machete to attack the young man that he
Yeah.
was shot 2 times.
Yes,
Yeah.
and I draw a distinction, Your Honor, between the holding up of the hand with the machete, which is a dangerous weapon, and my appellant coming with the gun, okay? And I am saying that in the circumstances of being confronted with a person holding up a dangerous weapon, it was open to the court to take the view that that was sufficient material to consider self-defense on the prosecution case. Allow me to draw a distinction. What, as I am going to show, the evidence unfolded was that, yes, 2 shots were fired, and the 2 shots were fired, according to Ramirez in that 6th version, I'll accept that, when the man was holding the machete. After he was shot, the machete came down and severely damaged. I don't think it was a complete severance, but it was a severe injury. And that followed, so it's an ongoing transaction over a number of seconds, right? And what we are saying is that the appellant did not shoot until he found himself being confronted with a man with a machete up in his hand, having fired 2 shots. The machete comes down, he suffers a severe injury, and there is evidence by Gomez that in fact there is a retreat, the appellant steps back, right? And that the deceased tries to chop again, and it is those circumstances.
Let me get this clear. You're saying sequence, machete first.
Machete raise.
Yeah, machete raise first, then gun.
No, I have to correct that. Let me be very clear.
Yes.
There is evidence from Ms. Gomez that the gentleman, when he was 2 to 3 feet away from Mr. Castellanos' Chile, that's when he produced the gun. So I think we have to start with the appellant pulling out the gun 2 to 3
So
feet
gun
away.
first?
Gun first, machete raised,
Uh-huh.
shots fired,
Uh-huh.
machete comes down,
Okay.
appellant steps back. At that point, Castellano comes back to try to chop a second time. Other shots fired. That is the scenario that we are suggesting to the court.
Okay.
Yes? So, that's the scenario. And our case is...
Before you go off, Mr. Sad, the paragraph 46, well, page 335 that we just had up,
Yes.
we underlined a part of it, and then there was a sentence after that. The judge says, however, I have looked at every possible sequence of events and cannot find evidence to support this or any other version. You haven't made a comment on that yet. So, is it then that, and maybe I'm going ahead of you, I don't know, but is it then that this evidence at page 78 and the composite that you have just described to us, i.e. Gomez, the gun is pulled, machete is raised, shots are fired, chop, retreat, that is the evidence that supports this?
And that is
And
my
so that the
argument.
material error for
Yes.
you would be that the judge, when the judge concluded that she cannot find any evidence, that is an error, a plain error, because of what you have constructed for us.
And that is correct. I
Okay.
think you have articulated the argument perhaps better than I could, but yes, that is one of the things I wish to get to in due course.
Could I just ask you, just to clarify the sequence in my mind,
Yes.
from your point of view, I understand what you have said about the sequence of the gun being drawn,
Yes.
machete being raised, shots being fired, chop, more shots.
Yes.
Was it the case that there was a question in re-examination to seek to establish the sequence of events?
Yes.
And,
Sorry.
if I may, and that question in re-examination, if you will, rehabilitates the version that you're relying on. Because the response in re-examination was that the shots were fired before the machete.
Yes.
And I gather you are strenuously objecting to that re-examination being asked of the witness. Are you?
I'll put it this way, please, Your Honor. When I looked at, it was a question posed by the court, so I'm not strictly sure it's a re-examination, but it's when the question was Chile shot before he attacked the young man?
Yes,
It's a very important question.
yes.
But I asked, what do we mean by attack? Is it, do you take the holding of the machete in your arm, in your hand upraised as an inference that was what the attack is? Or do you have to wait till the man brings on the machete to chop you to say that is the
No, it's
attack?
more than that. The question was Chile shot before he attacked the young man?
Yes.
Was he shot before he attacked the young man? But whichever form of attack you take, was he shot before? And the answer is yes.
If you construe the attack, the holding up of the arm, yeah, and this is where I have a little difficulty with the language being used. If he's holding up the machete in his hand, and you'll forgive me, but my understanding is that you are entitled in a self-defense scenario, if you honestly believe yourself to be under attack, you are entitled to fire those 2 shots preemptively. That is my understanding of the law on self-defense. So I put it in that context, please.
And I know you, obviously, you represent your client, and you do so very well, evidently. But what I'm saying is that from a judge's point of view, judge has no sides to defend. Judge is simply asking a question for information.
Yes.
And she's asking, was Chile shot before he attacked the young man? Answer, yes. So that then seems to be entirely consistent with the prosecution's case, that gun approached the sitting deceased, shot, stands up, attacks, if you will, with the machete, and shot further times. I am really trying to understand where a third version comes in, because I have a difficulty understanding what that third version is.
Yeah. Well, I'll put it this way. And I do hear what the court is saying, but my reviewing of that question is that, you know, I saw some ambiguity in it. That's the best I can put forward to the court, because attack, what do we mean by attack in these circumstances? And I am going to say, I am looking at it in the context of the principles of self-defense. You know, I've read many cases where self-defense is raised, and the person could be putting their hand in their pocket to pull, and the person on the other side, you know, honestly, reasonably believed that he was going to pull a weapon and strike, and then strikes. And there, you know, the jurisprudence is replete in self-defense about that.
But even on your view of events, Mr. Prasad, okay, so the accused stands up with a machete raised.
Yes,
Your client has a gun,
yes,
which is lethal from not just 3 feet,
agreed.
but from much more than 3 feet. Is there no other option but to fire how many, 15 shots into him?
No. With the
Six,
great
was it?
initially, I have to take this step by step. It's not 15 shots. And in fact, there's an issue. I think it was at 5 at most, but I will be subject to be corrected. on
Okay,
that.
no, I stand corrected. So
but
5 or
There were
6?
15 holes, or,
Yes.
you know, through the way the bullets went.
Yeah,
through.
let's not quibble about the numbers so much at the moment. What I'm asking is there no other option for dealing with a man who has a machete raised, according to your version of events, whereas your client has a lethal weapon in his hand?
Yes. I am familiar with a principle in self-defense, and sometimes you can't weigh up the niceties of trying to make a decision on the spot. I want to suggest to the court that what is happening here on the evidence is that for whatever reason, because the state of the evidence on whatever led to this is very poor. But what we know is that according to Gomez, the applicant produces the gun 2 to 3 feet away from the deceased, right? We have a situation here where the court has to appreciate that there was clearly something with the mother. I think that evidence is clear. When the appellant came in, he went to the mother pointed at the deceased, and that started the appellant walking towards. All we know is from Gomez witnesses that the mother did try to talk to her, and she said, I don't want to be part of that, or don't bring me in that, okay? So we don't know, because that was never fleshed out by any of the counsel. But it gets interesting. We have the witness Montefiore, who is the daughter of Canales, who is the owner of the bar. And Montefiore is told, go and tell Chele to leave. Now remember, we don't know what was the background and what was the story and why all this happened. And there is evidence that Chele, while sitting down saying, I don't want to leave, I'm waiting for Nevis, okay? We also know that Chele has a machete under the table, okay? Now, nobody saw him go to get the machete. All this happened over walking up 2 feet away, pulling a gun, and then the evidence on one version is that the gentleman stood up with the machete in his hand, and that's where everything flowed. Now,
So the law of self-defense is somebody stands up with a machete, and what do?
well,
You back off.
it all,
You back away and say, hold on, boss, hold on.
I have a gun.
You stay there. I'm going to say, I have a gun. You stay there.
I wish it was
But that is self-defense.
Well,
Self-defense is you avoid inflicting injury or harm.
If you can.
Well, I am going to suggest that the principles of self-defense allow for you, if you believe, and this is what I must stress on, if you honestly believe that you are under attack,
In imminent danger.
in
of attack.
imminent danger,
But this is a point. You are approaching this person. He is not approaching you.
we had put the case of Rashford for the consideration of the panel, and the case of Rashford said, even if you go seeking revenge, seeking vengeance, right? It does not preclude your entitlement to self-defense as a defense if you honestly believe you are under imminent attack.
Yeah.
And the most I can do is to put that as a proposition in law, and
As one of the cases you cited mentioned, the aggressor cannot be in self-defense.
well, the point about it is it's for the trial judge to assess the evidence.
So we know who is the aggressor. The man who comes in with the gun. Hold on, you said something to my mother? All right.
I'm going to put it this way, Your Honor. As I say, I'm going to just try to put forward my case as I think I should. In the context, we don't know what was the background.
Yeah.
And as I say, it's very poor, the quality of the evidence.
Does it matter?
Sorry?
Does it matter? Given the facts my brother has outlined, does it matter?
Well, you know, I think it matters to the extent that just because a man approaches with a gun doesn't mean he's coming to kill you. I'm going to put it that way because, you know, somebody can
Approaches with a drawn gun. Approaches with a drawn gun,
Yes.
as you admitted.
Yes.
Yes.
I am not going to say that this facts, or the facts in this case, that it was given that he was coming to shoot the man. All I'm simply saying is that yes, he drew the gun 2 to 3 feet away from the deceased, but something happened at that point.
Yes, he stood up with a machete
Stood up with a machete.
to defend himself.
I'm going to say this. why was this appellant not entitled to take the position that he felt threatened? Why is he, is it that just because he came with the gun
So,
first
Mr. Prasad,
in time?
let's, I think we were going over these versions, but is your criticism that at minimum the trial judge should have considered this because there was sufficient evidence to consider it, even if at the
Live issue.
even if at the end of the day, as we are debating now, she ended up concluding, I don't agree. For the purposes of this appeal, are you for the moment focused on what should have been the final outcome, or are you on the point of process that on the record before us, this evidence is there, that this is not a fanciful possibility, and so the trial judge had a minimum duty to consider it. And in the paragraph you raised for us, where she says there was no evidence, that you say, I believe, that is plainly wrong because there was some evidence. And so the criticism you have is not so much in outcome for the moment, but that the accused never got the benefit of that consideration. Is that what your argument is?
That
Because
is
right
indeed-
now we're debating
Yes.
what should be the final outcome.
Yes. No, and I take that point, but I am on process. I am on what the learned trial judge should have done. I do appreciate that there's, a bantering in terms of what the evidence was, but my position very simply is that there was sufficient material to make it a live issue for consideration.
Okay, I think we have that point very clearly, as assisted by our brother. Is there any other point that you wish to urge on us?
Well, I'm going to put this scenario of the evidence and, to be clear, and if the court wishes, I could take you to the actual evidence. But the simple point is, 2 feet away, produces the gun. The gentleman stands up with the machete in his hand. I take the position that when one looks at the principles on self-defense generally, what the tribunal has to do is give consideration to the issues if there is a sufficient basis to raise that issue. And we say there was a sufficient
The
basis.
Prasad, and the judge considered that version and dismissed it.
Yeah. We follow on that point as well. So my question is there any further points that you wish to engage us on?
Well, what I would like to do is take the court to the analysis by the learned trial judge and take you through how the court approached the process. And I'm hoping that will be of
But with the
assistance.
greatest of respect, what benefit would that provide to us if you cannot tell us where she went wrong? Whatever the evaluative process, what was the error at which she arrived, having done that analysis?
What I propose to do is going through that is to point out where she went wrong. The learned trial judge. I hope that answers, because that's the exercise I wish to do now. Because what I am saying is that the learned trial judge, in her analysis on self-defense on the prosecution case,
Okay.
failed to properly appreciate the evidence, okay, on the account that we have said, made some material errors, and we are saying that if, and the court has to cross the boundary, as I say, of agreeing with me on whether it arose to a certain level. That, of course, is a matter for the court. But if the court finds that it was a live issue, then we say it triggered certain principles of law that had to be considered by the judge and certain appreciation of facts.
Yes.
That is the best I can answer.
Mr. Prasad, we have about 15 more minutes on your time, yes? So
Okay,
if you wish to use it in that way, then...
Yes, I
that's
didn't
fine.
appreciate I was getting to 15.
And Mr. Prasad, you already have clear from me that the judge considered the various scenarios and rejected the one other than the one which she came down in favor of.
Yes.
So I can give you the assurance you will hear nothing further from me.
But I would so look forward to.
Use your time profitably.
No, thank you. So I'm taking the court to page 333 of the record. I don't have paragraphs, but that's accurate. There is, on the last paragraph, there are essentially two versions of what happened in the restaurant that night. Your Honor's with me.
Yeah.
In one version, the deceased initiated the attack on the accused, and in the other version, the accused initiated the incident. Now, the first version there is talking about the appellant's defense, which was rejected, in my view, correctly. And that's one version, according to the trial judge. The other version is the accused initiated the incident. Now, I accept that the accused initiated the incident by walking up to the deceased and shooting before he was chopped and before the deceased pulled the machete out. Now, I can't put it any other way. That is not my understanding of the evidence, because it was not a situation where he shot when the deceased pulled out, before the deceased pulled out the machete. The timing is important. According to the trial judge in her decision-making process, she is taking the view that the accused initiated the incident by walking up to the deceased and shooting him.
Right.
Shooting. He was chopped, before he was chopped, and before the deceased pulled the machete out. Now, so my first position, I do not understand the evidence based on the cross-examination of what Mr. Ramirez said, and in my view, he took the position that the gentleman was shot when he raised the machete, so the machete was already out.
Yeah, I think we have covered that point.
Cover that.
Yes.
Good.
Because I think you would acknowledge that he was not the only witness. The judge heard from a number of witnesses.
Yes.
And the result of hearing from that number of witnesses is that the judge concluded as you have just read.
Yes, but I do say...
On the totality of the evidence.
Yes, and PCCJ, I make the point that the other witnesses were not eyewitnesses to the actual shooting. I make the point that Ms. Canales just heard the two shots. Ms. Gomez was eating her quesadilla and only looked up after she heard the first two shots, right? And Ms. Montefort did not add any evidence. So it really turned on Mr. Ramirez. There undoubtedly was some movement in the start of the incident. Deceased standing up upon seeing the firearm pointed in his direction and quickly pulling the machete out to defend himself. So this is saying that the gentleman, stood up and pulled out the machete to defend himself. Now, goes on to line 10, please, page 335. Mr. Ramirez said that Castellanos, the deceased, was shot and then the machete appeared from where the witness could not say, and the deceased responded by chopping the accused and who continued to chop him. We say
Shoot him.
Continue to shoot him. We say that that is not an accurate reflection of the evidence. And allow me to make this point. To the extent that we are saying that there may have been an inconsistency, there was 5 versions versus 1 version, etc., I think that the trial judge has to deal with that inconsistency. If a trial judge is dealing and summing up to a jury and their material, the trial judge has an obligation to tell the jury, ladies and gentlemen of the jury, one person has said this, he then comes and says something else. I give you 3 directions.
But remember, there's no jury here.
I remember, I accept that.
Yes.
But there is a need for the trial judge to show appreciation of the salient points of law. To the extent that it has been raised that there's an inconsistency, then I say that the learned trial judge had to show an appreciation of that inconsistency and ask itself, is it a material inconsistency? Is there explanation for it? I think the panel will understand where I'm coming with that usual direction. Moving on to the bottom of page 335, line 18, I have considered that the accused may have approached the deceased as he sat, and the deceased rose with the machete and put the accused in fear, resulting in him shooting the deceased. However, I have looked at every possible sequence of events and cannot find evidence to support this or any other version of the accused of what happened that night. And we say that is plainly wrong. We say it is plainly wrong because the evidence is there that suggests that what was happening on a scenario was that appellant approaches with the gun from 2 feet away. He produces the gun 2 feet away. And at that point, the gentleman who was waiting on him, because he had said before that he was waiting for Nevis, right, stands up, pulls out a machete, all right? And so you have a man with a gun, a man with a machete, and I am saying that when you juxtapose that to the principles that relate to self-defense, it was possible for the learned trial judge on that evidence to say the appellant could have had an honest belief that he was about to be attacked. Now, there was a...
Assuming that she believed that version of events.
Assuming
Yes.
that she believed. But there is no analysis on that issue. I just put on record.
Okay.
There's no record. And so it suggests to me that the judge, having rejected the appellant in his defense, and having come, we say she had a duty, an obligation to do that. And it is arguable that she may have apparently appeared to have put a burden that this appellant had to have said, I
Oh,
was
no,
in fear
no,
of my
no, no,
life.
sir, you want to go there? Because she made quite clear that there was no burden on the accused to prove anything, surely.
So our position is going to be that in relation to her lines 21, 22, 23 at pages 335, it was plainly wrong, and that the learned trial judge did not give sufficient weight to what we say was the evidence before her.
Okay.
And I will close off my, Your Honors. Based on the prosecution evidence, I accept as true. Well, if there's an inconsistency, what are you accepting as true? Which version? I do not believe the accused held an honest belief, or even may have held an honest belief, that he had to defend himself on the deceased. Simply put, I am saying that from a process point of view, I say that a judge sitting as a judge alone in these circumstances, when confronted with the evidence of it, should have at least shown in her adjudication, in her reasons that she was putting forward, that she was rejecting one version over the other to the extent that there was an inconsistency.
So, Mr. Prasad, what do you say of the conviction in that light? What do you tell us what is the result? I think Justice Jamada
Yes.
had
Well,
asked
my view
that.
is this, that if the court finds that there was a failure to properly consider the evidence and to properly apply in the process of adjudication the legal principles that arose, it renders the conviction unsafe. Unsafe. And we would respectfully ask for the quashing of the conviction in those circumstances.
Would the proviso apply in that case?
No, please,
Why
Your
not?
Honor, because the proviso is generally used if there's a technical failing or misdirection, etc. But what
No, it's used, as I understand it, correct me if I'm wrong, to say, well, even if there was an error, there was no miscarriage of justice, and therefore there's no
yeah.
need to overturn the verdict.
Yes. So we say there has been a miscarriage of justice.
Oh, you
Because
do?
if there is any merit to what we are saying to you, to the panel, essentially, we say the judge should have at least addressed her mind to the possibility of self-defense arising, and therefore you have, by not doing that, deprived the appellant of an opportunity to a defense. And the cases on that area usually says, I want to go back to some old cases, but that where a defense, I think it's Bajan, Aram Bajan, and those cases that talk about where a defense is not properly put, Batiste and those cases are, then you cannot apply the proviso because you have deprived the person of the chance to have the benefit of a defense. And that is something that it's certainly not technical, and it certainly is not something that the proviso will cure.
Okay.
I think I'll put the submission like that.
Okay.
Mr. Prasad, I find that very interesting, the argument here and your arguments today. But I wanted to just ask you, have you looked at it from the point of view that this is a judge-alone trial? And so there is, from what I saw in Salazar and so on, a little more nuanced approach, let me put it that way, because you're not dealing with a jury. You could give us some assistance, because I'm sure you've thought it through.
I have thought it through. I have to say I'm a little biased. I come from a jurisdiction where magistrates have long dealt with criminal matters.
Judge alone.
When those magisterial appeals come, the appellate court has always taken the position, I think it's a case called Sylvan and Raghunath, the need for reasons, that this fundamental principle comes, that the judicial officer, and I'm talking about magisterial summary matters where there's no jury trial, must show in the reasons a salient appreciation of the salient principles of law and the salient facts. And that is how I have couched it. Now, quite frankly, do I see a distinction between a magistrate presiding over a trial and sitting as a fact-finding tribunal and a judge without a jury? I think the principles are equally transferable, because you really, as someone who is reviewing or looking at a summing up and reviewing a conviction, you really need to be assisted by the judge showing that the judge appreciated law and fact. And in this case, I think the panel appreciates it. My complaint is that because the evidence appears to be a lot more robust than what the judge focused on in her analysis on summing up, and that she just puts it at highest, it seems that, you know, the man came with a gun, he shot him, but does not contextualize it. And I think we go to pains to try to show that. And because maybe I am predisposed because I'm thinking self-defense, and I look at the principles of self-defense, and you can take a preemptive strike, and you can, you know, I have always known that, I've always learned it, that, you know, you don't have the time for the niceties of thinking I'm going to retreat, etc. That's not how I...
So even in a judge-alone trial, the judge ought to have singled out that issue, addressed it specifically, and reflected that in her judgment. Is that?
I could not complain if that was done.
Okay, thank you very much.
Unless I could be of any further assistance. Or
No.
Thank you.
Thank you.
Thank you so much, Mr. Prasad. Thank you. Respondents, please.
Your Honor. Obliged, Your Honor. The position of the Crown is that there was in fact no foundation for this third version that is being argued by the appellant. The facts being advanced are simply not borne out in the actual evidence. So if I may first take your honors to the evidence of Donovan Ramirez, but to his total evidence, what was said on this issue in his examination in chief, what he said in cross-examination, and then the actual words that were said in re-examination to show that there was ultimately no inconsistency in the account that he had given in examination in chief as to the actual sequence of events. So if I may take your honors first to page 69 of the record. If I may, your honors, from the beginning of his evidence on the point. We were there at the restaurant. We were conversing with Castellanos. While we were conversing some things there, a young man arrived with his firearm. He walked towards a lady. The lady got up. She pointed at Castellanos.
I'm sorry, this is whose evidence? Oh, this is Ramirez?
Yes, Your
Yeah, okay, good.
Page 69. He walked towards Castellanos where he was sitting down in a chair, beige in color. He took out his firearm and he shot him. I don't know how he did it or where he got the machete, and he attacked him. After the 2 shots, he continued shooting at him in his chest area. While Castellanos tried to come out of the restaurant, as he was coming down the steps, he continued shooting at him. After that, I don't know what happened because I took my bicycle and I left the place. Then, in cross-examination, so if I may take your honors to page 72 of the record. He says, when it is put to him, you did not see any lady stand up and point towards Chile. Yes, I saw. You saw where Chile got the machete from? No. He took it out of his pocket? No. He took it out of his pants waist? It was so fast that I couldn't notice from where he got it. And if I may take your honors down to page 73, just at line 12, you were playing with your phone. You didn't see anybody come in with no gun in their hand. They asked me if I saw what was happening. Who asked him? Just now, you asked me if I was watching television. I was playing with my phone, but as I saw the movement, I placed my phone and I saw what was happening.
That word bothered me a little bit. Maybe it's a local vernacular. When he says, I placed my phone, what does that mean?
He
Put his
put down
phone
his
aside.
phone.
Yeah, put it on the phone. Okay, yeah.
On the next page, page 74, line 8. You saw a young man with a gun in his hand come into the restaurant? Yes, I saw. And you saw that same young man walk up to your friend Chile, who was sitting down? Yes, I saw. And he pointed the gun towards Chile? Yes, he pointed. Did you say anything to Chile, your friend? No. Did you say anything at all? No, nothing. Were there other persons in the restaurant while this was happening? Yes. Then at page 75, So you're telling us, this is what is being put by defense counsel. So you're telling us that Chile was sitting down and a young man come and shoot him 2 times in his chest. At that time, Chile had a machete in his hand and he got up to attack the young man and he went towards leaving the restaurant and the young man was shooting him in his back. But you don't know what happened to the machete. The judge points out that it's a compound question and
We're not seeing where you're reading from. It's not on the screen.
Yeah, you need to go a little further. Next page.
It goes over, leave to page 76. Yeah.
Yeah, quite a compound question. That's in 76, yes.
yes. And the court pointed out that it was a compound question, but the witness did at line 10 answer saying yes. Then it is put to him, you did not see what you're saying to this court. That did not happen. The witness's response was, I disagree. Chile did not get up to attack the young man, but then went away towards leaving and have no machete and a person so shoots him in the back. You did not see that. Yes, I saw. You are telling this court that your friend Chile is sitting down. A man is walking up to him with a gun. He has a machete, but he is shot 2 times in his chest before he can get up. Is that what you're telling us? And again, the judge intervenes because it's a compound question. The attorney puts it again. The judge says what he has put is actually mischaracterized. So now on page 77, the last question at the bottom of the page. I'm suggesting to you that your friend Chile chopped the young man with the machete. Answer on page 78, yes. Yes, ma'am, why didn't you tell us that before? Because he was just trying to defend himself. So, he was standing up when he got shot? Yes, he was standing up. And it was when he was going with the machete in his hand, that is when he got shot. He was shot before that. He was shot before when he got 2 shots to his chest area. This response is very important, Your Honor, because this is not the witness departing from what he had said before. In examination in chief, he very clearly said the sequence was, this man came with a gun, he pointed it at Chile when Chile was seated, and then he does not know where Chile got the machete from, but he stood up with the machete. He is saying here, in relation to the question being put to him, that when he had the machete, then it's when he was shot. His response is he was shot before that. He was shot before when he got 2 shots to his chest area. This is not an inconsistency. He is repeating what he has said in examination in chief. So the question is, Chile got 2 shots and then he raised the machete to chop the young man. It was when he raised the machete to attack the young man, that is when he was shot 2 times. And then he turned around and he went down the stairs and he continued shooting him. From behind, yes, from behind, and cross-examination ends. So in re-examination, clarification is sought because of that last response.
Pause for a minute.
Yes, sir.
Before we initiate re-examination, can we just go back a little higher on that page? Because those 2, no, right, yeah, right. Good, a little bit further up. No, a little more to the top, right? So that his sequence is that he was shot, correct?
Yes.
And then he talks about where was he? He was shot. He got 2 shots, and then he raised the machete, right? Machete, whatever we say. So the cross-examiner is trying to clarify what happened. Yes?
Yes.
And then the witness says, in clarification, it was when he raised the machete that he was shot 2 times. Yeah? So are you saying to us that that answer, the last answer, is consistent with what came before?
When it is read along with the clarification in re-examination, Your Honor, that is my position.
No, I know we come to the re-examination in a minute, but up to this point, are you saying that the answer to the question immediately before this one, you remember you just read it for us?
Yes, Your Honor.
And this, I don't know if you want to say expansion or it's a probing question in cross-examination to maybe clarify, get the picture. He says what he says. Would you say those 2 answers are consistent?
I would, Your Honor, because his position is that he also got 2 shots when he raised the machete. And this is what he's saying here. the question is, Chile got 2 shots and then he raised the machete to chop the young man. It was when he raised the machete to attack the young man that he was shot 2 times. And then he turned around and he went down the stairs and he continued shooting him. His sequence before was Chile seated, Betancourt, the
Shot him.
appellant, comes, shoots him while he's seated. He raises the machete. He
So, all
Gets
right,
the
so the
machete and
sequence
raises.
before is that he's shot while seated. I think you went through that with us.
Yes, Your Honor.
All right. That's a plain enough scenario to imagine. Here, he is saying that, was he seated? Is he still saying that he was seated when he was shot?
No, Your Honor.
No. He is saying that he was standing when he was shot. So that is one difference, at least, between being seated and shot and standing and shot.
If this were taken in isolation.
No,
yes, Your Honor.
I'm not, I understand, I know what you want, what you're going to do with us. I'm just asking you, you see, you are saying all of the evidence is consistent, but the earlier, I'm pausing now, I understand I am pausing now, and you're going to take us to re-examination. We've all read the transcripts. His first piece of evidence is that he was shot twice. When the man comes in, goes up to him, he is seated, he shoots him twice in his chest. Agreed? Evidence in chief.
Yes.
Good. Open and shut. In cross-examination, we have the first nuance on that. That is to say, he was shot twice when he was, I'm leaving the machete out for now. He was shot twice when he was standing. Do you accept that that is what this latter piece of evidence, both pieces, both the earlier piece and this piece, that's what it's saying, right? You agree with that? That the evidence is saying that. I'm not asking you what I'm just asking whether this evidence is saying he was shot while standing.
This evidence, yes, Your Honor.
Good. Then there is another little nuance. It's the question of the machete. Is the evidence saying, or is there a reasonable interpretation, maybe that's a better way I should put it, is there a reasonable interpretation on this evidence that what the witness is clarifying when being probed in cross-examination is that the machete was raised and then he was shot?
Yes, Your Honor.
All right. Do you agree that if we pause for now, that is inconsistent with the earlier evidence in chief that he was shot while sitting down?
If that response from lines 15 to 17 were read in isolation.
No,
yes,
I'm
Your
reading it in juxtaposition with what he said in chief. He said I don't want to rehearse it. I'm just asking you whether you agree that this is inconsistent with what he said in chief.
No, Your Honor.
No, why is it not inconsistent?
Because in examination in chief, he spoke about Chile having received several shots. He was seated, he was shot. He got up, he had pulled the machete, and then he was shot again. And so when he is saying here that when he raised the machete, he was shot, this is not inconsistent with that version that he gave.
That he was
before.
shot before this while he was sitting down.
So your thesis is that he was shot before while seated.
after.
He got up, chopped, and he was shot again. There were 2 shots before he got up with the machete.
Yes, Your Honor.
There were certainly, from all the evidence, more shots after he did the chopping. So there had to have been 3 more shots after the first 2 and after the chopping. Yeah?
Yes, Your Honor, and the evidence of the other
Yes.
witnesses were consistent with 2 shots having been fired, and then the deceased standing with the machete and firing the chop towards the appellant, and the appellant continuing to fire the firearm.
And that
And
was,
just before this, he had said, in response to the question at line 10, and it was when he was going with the machete in his hand, that is when he got shot. He was shot before that. He was shot before when he got 2 shots to his chest area.
Where's that there? Show me, where's that evidence?
It's on the screen, Your Honor. The question is at line 10 and the answer at line 12.
And when he was going with the machete in his hand, that is when he got shot. He was shot before that. He was shot before when he got 2 shots in the chest. That's his evidence in chief.
No, Your Honor, this is cross-examination.
No, what I'm saying is, sorry, my mistake. That is consistent with his evidence in chief.
Yes, Your Honor.
Right.
That there were 2 shots before the machete was drawn.
Yes. So that his answer at line 15 has to be interpreted as what happened after those 2 shots in his chest. That's what you're saying.
That is my position.
Right. And you say this is made pellucidly apparent in the re-examination.
That is
So let's look at that. Yeah.
Go to the re-examination. So the re-examination is at page 79. Right there. So this is the question being asked by the...
What page is it? 79?
Page 79. May I proceed, Your Honor? Was Chele shot before he attacked the young man? The answer is, there were 2 shots before, but they didn't harm him. So when he was speaking about shots before, in his mind, those first 2 shots did not harm Chele. It was subsequent to the pulling of the machete, etc., that, of course, is inconsistent with the medical evidence.
Also, the question, when Chele shot, was Chele shot before he attacked the young man? What is that question getting at?
Because of the response that was given in cross-examination in relation to whether it was when he had the machete
Please.
that he was shot.
He's asking him, was he shot before so the he attacked is before Chele attacked. So this question is based on a premise that Chele attacked the young man.
Yes, because in cross-examination he had said that Chele was defending himself, and so he had used the machete.
All right.
That was his evidence
So
in
the
cross-examination.
prosecutor is saying, before he was shot, before he attacked the young man, was he shot? And then he says, yes. There were 2 shots, but they didn't harm him. That's the answer.
Yes, Your Honor.
And you say that is when he was shot in the chair.
Yes, Your Honor.
But those shots did not harm him.
According to this witness's perception.
And what did the
of
forensic
activity.
evidence say?
The forensic evidence would not have been able to reveal which shots occurred.
But where
in
was
what
he shot? And
He
how?
was shot at least 4 times in his chest
In his-
and stomach area.
And his stomach area.
Yes,
So, all right, so he was shot twice in the chest and twice in his stomach. Did the forensic evidence reveal the damage caused by the shots to the chest area?
Yes, that is what ultimately led to his death, because they
So
caused
were
injuries to
those
his
considered
lungs.
to be the fatal shots?
Yes, Your Honor.
And that was where he was shot when he was seated, in his chest area.
Well, also when he stood up, because the other witnesses say that he continued firing at
No,
Chile's chest.
I'm on the evidence. The evidence in chief was that he was shot while seated in his chest area. That's what you told us.
If I may just go to the...
Yeah.
At page 69,
69, yeah?
at line 16, he said, after the 2 shots, he continued shooting at him in his chest area. So he got the 2 shots when he was seated, and then after his words are, he attacked him. After he attacked the appellant continued shooting at him in his chest area. So
So the chest shots happened after.
according to what the witness says here, the forensic examiner spoke of 6 entry wounds.
2 in the chest.
Left collarbone, right lower chest, right side of stomach, in front above the hip, above the right knee, and there was an entry to the right biceps.
But which were
area.
the entries from the front? Because I believe not all those entries were from the front, right?
Left collarbone, right
Yeah.
lower chest,
Right.
right side of stomach,
Mm-hmm.
and in front above the hip.
Yeah, Consul, sorry, if you're finished.
No,
I'll go ahead.
I'm finished now.
Thank you. I would like to ask you a legal question. I know that your version of events basically was accepted by the trial judge.
Yes.
Let us suppose, however, that the defense's point of view, the accused man's point of view, had been accepted, which was that he approached the deceased with his firearm drawn. There's no question about that. The deceased stands up with a raised machete. In those circumstances, what is your view on the legal rights of the accused to defend himself? Do you think an issue of self-defense arises? Just to repeat, the accused is apparently the aggressor because he approaches this chap who is sitting down. Chap stands up, produces a machete from nowhere, and raises the machete even. In those circumstances, do you think, as a matter of law, that the accused would have had a right of self-defense?
Your Honor, my position is just as the judge analyzed the situation to be. The judge concluded that, in fact, the appellant was the aggressor. So him having gone there and drawn his firearm, it was not the appellant, as counsel has been arguing, but the deceased who would have been legally entitled to take a preemptive strike. This is a person who is approaching him with a weapon after he has had some kind of disagreement with this person's mother. He is approaching him with a firearm. He is entitled to take a preemptive strike. When my learned friend spoke about weighing the niceties, it was Chile who, we should appreciate, wouldn't have had time to weigh the niceties of whether the appellant was coming to merely threaten him with the firearm, merely to show him that he had one, or to use the firearm against him. So he is the one who was entitled to defend himself. The cases relied on by my learned friend, as I pointed out in my written submissions, do not avail the appellant. They make the point very clear that if it is you are the aggressor, then looking at the circumstances, you can't turn around and say, well, this is how this person reacted when I did this. And furthermore, Section 36 of our criminal code sets out very clearly that a person who is engaged in an unlawful fight cannot justify the use of force. An unlawful fight is any fight that is initiated without one of the justifications. So this appellant was the one who started this. He was the one who was not being attacked. He had no issue with Chile. He was not there when Chile was doing anything to his mother, so he was trying to defend her. He came on the scene after the fact. He went up to Chile with the firearm.
Yeah, so can I ask you something? So as a question of law, you would say that Section 36(6) would operate in such a way that the judge was not under a duty to consider self-defense in favor of the accused. You see, the criticism here is not the outcome. The criticism is whether, in this scenario, the judge should have considered self-defense to the benefit of the accused, right? That's the argument before us as I understand it. Is it that you're saying that Section 36(6), the operation of Section 36(6) as a question of law would have meant that the judge was not under that obligation? Because of what you just explained, is that what you're saying?
I'm saying, Your Honor, firstly, that it could not have been resolved in his favor. There could not have been a finding that he was acting in self-defense on those facts. But the learned trial judge, of course, would have been under an obligation to consider whatever is raised on the facts. This was not raised on the account given by the appellant himself, and my submission is that it was not raised either on the prosecution's case. There's simply no third version. But if I may go on, I know that my learned friend took your honors on several occasions to page 335, but if I may take your honors to page 335 of the record. May I proceed before it's up on the screen? Would you honors require to be up on the screen?
Well, I would rather wait so I can follow you. I mean, I trust your reading, of course, but trust but verify, right? Yeah. You can put it down in that way, yeah, sure. Yeah. Yeah. Where are we going? 300 and what?
335.
So we're there now, yes. Back to 334.
So in this part of the judgment, the judge recounts the evidence and then concludes at line 17, this is consistent with the deceased being shot and then chopping the accused. And then the trial judge goes on. I have considered that the accused may have approached the deceased as he sat and that the deceased rose with a machete and put the accused in fear, resulting in him shooting the deceased. However, I have looked at every possible sequence of events and cannot find evidence to support this or any other version of the accused of what happened that night. Clearly, the learned trial judge gave thought to that version and rejected that as well. The judge goes on.
Before you move on, but
Yes.
that's not the point, is it? The point is whether or not the judge was plainly wrong in saying that you could not find any evidence. That is the thrust of the appellant's argument. It's not whether the judge considered it and did not agree or on the balance found otherwise. The question is, at least in my mind, what is being put is, when the judge said you can't find any evidence, is it that in that little thing that we went through, the cross-examination, you remember? That little scenario, page 78. Is it that there is evidence where there could have been such a scenario? Is
I
your
would have
answer
to
to that
say-
no?
I would have to say no, Your
All
Honor.
right.
So put another way, sorry, if the conditions were reversed, and if the deceased was sitting there with a gun, and the accused enters with a machete, so the accused is the aggressor, yes, but he has a less lethal weapon, knife or machete. And the deceased stands up with a gun, loaded gun, cocked to shoot. I'm just trying to follow on the question I asked you earlier about whether an aggressor can ever have self-defense as a possibility. In those kinds of circumstances, that may be a possibility, would it not? Because even though you're the aggressor, you're going to a gunfight with a knife. And if you go into that situation and the person pulls a gun, then, logic suggests that you may want to defend yourself by making contact with your knife. That does not apply in the facts here. I understand what you say, I understand what the judge says, but I'm not saying it's a matter of a thought experiment. That might be a possibility. Would you agree?
Your Honor, if the situation were as Your Honor outlines, and the appellant had gone within 2 to 3 feet of Chile with a machete, Chile would still have been able to defend himself if he had a gun by shooting him.
So
a machete is only, as has been said this morning, less lethal because a gun can reach further. But on these facts, he was 2 to 3 feet away at one point, according to one of the witnesses. So Chile would have thought his life in danger with a man wielding a machete, and he would have been entitled to take a preemptive strike long before the appellant would have been able to chop him.
So just my final question on this then, in no circumstance can the aggressor claim self-defense. Is that your position?
That is not my position.
Oh, well, what is
If it is and I believe this comes out of the case that was cited
The
by
Radcliffe case, yeah?
my little friend, if it is someone has, and this is the reason that it was being put, that this is a less lethal weapon. If it is you go to have a fist fight with someone and someone pulls out a deadly weapon and inflicts injury on you, then that's a wholly different kind of conversation that needs to be.
But can I just tease you a little bit about Section 36.6? Let us take away the comparative lethal weapons, machete versus gun, because I take your point that maybe it's 6 of one, half a dozen of the other. I take that point, you know what I mean? Especially in close proximity. But suppose, as you say in the last scenario, you go with you are the clear aggressor. No doubt you're the aggressor, and the person takes out a lethal weapon. Yeah? How does Section 36.6 play out in that scenario? Because Section 36.6 appears to be saying that an aggressor, does it say an aggressor with a co-equal lethal weapon? It doesn't. It just says an aggressor. So I'm just asking hypothetically because there is some reliance on Section 36.6, which is why I asked you earlier whether Section 36.6 absolves the judge of any duty. So let's just take this scenario, your latter scenario, fist versus drawn lethal weapon, but the person with the fist is the aggressor. Does Section 36.6 avail?
I would think in those circumstances, the judge would still have to ask herself the
All right, just hear my question. So are you saying that Section 36.6 will not apply? I don't want to get to the case. You just, you self-defense is not an option, right? That's what it appears to say. So let's stay with the scenario. Would Section 36.6, is it 36.6? I don't remember now.
Yeah,
Would it apply?
I know that the answer has to be no.
Why do you say, but don't do that. Don't tell me what you know the answer should be. Come on.
Because clearly it would not be just if someone went to a fist fight and someone took out a machine gun and...
Well, if you accept that premise, then it puts a question mark over the ease with which 36.6 can be deployed.
Except that this was not a fist fight that they have.
No, I understand. I'm very clear. I'm very clear on the facts. Don't worry about that. I'm just trying to understand the law because the argument was advanced that 36.6 is an answer you are now, I think, accepting. In this case, it may be an answer, but in all cases, it may not be. Is that your position?
Yes, that is my position.
What would make it, sorry, I just wanted to clarify, what jurisprudentially, what would make the difference? How do we figure that out? But if President, you can go ahead.
Well, no, I was just wondering whether your answer is that as far as these facts are concerned, you have given an answer, and that these other matters,
I was not able to.
as far as these facts are concerned, you have given an answer. And as far as the hypothetical situations are concerned, raised by myself and my brother, Justice Jambadar, they're not immediately before us, and perhaps you may be hesitant to offer an explanation. Am I reading you correctly?
That would definitely be the position I would want.
Thank you.
You're indebted to the generosity of the President.
Ms. Vidal, I wanted to go back to, well, I keep looking at the written judgment. You all apparently reading from the oral judgment, but at paragraph 46, the same statement, I have considered that the accused may have approached and so on. It does appear then that the trial judge understands, let me use some broad language, understands the last bit of cross-examination of Mr. Ramirez in the way that he clarified it then. And then it seems as if she may have lost a little patience with him, because she asked him directly the question, because he said, the shots didn't hit him or something. And she just wanted to know what happened, just tell me that. But she seems, therefore, to take what he says in re-examination and accept that as the version of events which would therefore make all his evidence consistent. Am I right on that?
This was the point that I was trying to make earlier.
Yes,
Your
that's the
Honor,
point. That's what I...
ultimately,
Yes.
the evidence was consistent, and I wanted to go
But
on.
before you go there, well, you can go on to that, but I wanted to ask you something about that. Was she duty bound because of the nature of the trial and because of the principles of law that Mr. Passad helpfully took us to today? Was she duty bound to put on this statement that was made a different interpretation which would be in favor of the defendant? So as you answer where you wouldn't take us, if you could put all of that in the mix,
I'm
I'd be
very happy
happy.
that Your Honor has asked the question. This is what I wanted to argue in Keith and was not able to. The judge should approach the case from the point of view, in my respectful submission, that she looks at the evidence and she determines what evidence she accepts. Based on what she accepts, she looks to see what defenses have arisen on that evidence, whether they have come from the accused himself or whether on the prosecution's case that defense arises. And then the judge must conduct her analysis in relation to each of those defenses and come to a conclusion. So that if this is the version of events that is accepted by the trial judge, after the judge has gone through in the judgment the evidence of the witnesses and said which witnesses she believed, what she did not accept, if on this version, this is what she is going to consider the case on, then why then would the judge, since this is not raised in the defense case, why then would the judge be considering a defense that does not arise on evidence that she has accepted as true? And this is the point I wanted to make in the paragraph, right after the paragraph that I just read, in the same paragraph that Your Honor pointed me to. So it's at the top of page 336. If I may read?
Yes.
Yes.
Based on the prosecution's evidence that I accept as true, I do not believe the accused held an honest belief, or even may have held an honest belief, that he had to defend himself from the deceased. The sequence of events has the accused approaching the deceased as the deceased sat in the restaurant. The evidence supports that the deceased pulled the machete from wherever it was only upon realizing he was under deadly threat, that is, seeing the gun pointed at him. I did not reach the second question in the analysis of self-defense being if there had been an honest belief that he needed to defend himself, taking the circumstances and danger. Did the accused use more force than was reasonable? I did not reach this part of the analysis because, in my view, the evidence does not support that the accused had an honest belief that it was necessary to defend himself. Accordingly, I am of the view that the accused did not have any lawful justification when he fatally harmed the deceased. Having considered all of the evidence, having looked at the evidence of Donovan Ramirez and stated what out of that evidence the trial judge accepted as true, the trial judge then considered the defenses based on that evidence that she accepted. And her conclusion was that this person was the aggressor, and the reaction of Chile was only after that aggression from the appellant. And so in those circumstances, she could not accept that he was the one who would have thought he had to defend himself.
So let me just understand then. So in a judge alone trial where the judge is the trier and the finder of fact, does she simply say, well, I accept this, and therefore this is the consequence?
Yes.
Or can she or must she then say, but there is another version that is possible based on what Mr. Ramirez said? Because I thought that's where she was headed. I've considered that the accused may have. I thought that she was going to the third version. And she says that, but she says, but it does not accord with his case. That's how I understand it. It doesn't accord with the events. One, does, the evidence does not accord with his case, one, and two, any version of it that I see.
So
Is she entitled to do that? That's what I want to know. Or must she go further and say, but I will consider self-defense on this, and this is the result?
But Your
That would
Honor,
really help.
This was part of the judge considering self-defense. The judge went through a process where she analyzed the evidence and she came up with the version of events that she accepted to be true. And she this was part of her discussing the element of unlawfulness. And then she stated what she accepted as being true, having looked at the totality of the evidence, and came to this conclusion. So the judge did go through that process. If the judge rejected the evidence that would have established a particular defense, then there's no onus on the judge to then consider that offense. That is part and parcel of really the consideration that I do not accept these facts, so that this defense cannot avail the accused.
Whereas if there was a judge and jury trial, she may have had to explain
Without
that.
a doubt, because the jury would have to first determine what facts it accepts. So the judge would have to direct the jury, if you accept the evidence of these witnesses, these defenses arise, and this is how you will deal with these defenses. But this is the judge of the fact herself who is setting out the evidence, analyzing, saying what she accepts, what she does not accept, and in the context of that, what defenses she thinks are open and what can succeed and what will fail.
And none of our judges suffer from schizophrenia, so I think we follow you.
I have no comment on
Touché. One last question on that. I may have missed it, Ms. Vidal and perhaps Mr. Prasad when he comes back, but was there any learning on how to treat with judge-alone trials and the defense of self-defense that you all put to us? As I say, I may have missed it.
Specifically in a judge-alone trial? No, Your Honor, I have not come across.
Did you look fit? I don't mean to embarrass you at all. No, I don't mean to embarrass you. So please feel free.
Your Honor, I looked at cases in relation to self-defense, and the Ferdinand Manzanero case did come before this court, and there was a dicta in that case in in relation to how the conclusions of the judge can be dealt with by an appellate court. But in terms of specifically setting out in a non-jury trial, this is how a judge must approach the area that dicta, as far as I've read it.
You haven't
Doesn't
seen
appear
that.
Yeah, and I say that that was part of the reason that we were happy to hear from you this morning, so that this court can make a pronouncement on this area. You still have another 12 minutes to go if you have further.
President, if you could,
submissions.
there is one little question I'd like to ask. If it is that at the end of the day we are of the view, or some of us are of the view, that the judge could have gone a little further in the self-defense and, for example, said that in the event that this happened, in any event, it would not have met the requirements because, and you've played out the scenario, the gun versus the machete and the distance. Suppose you have the view that the judge should have engaged that because it did arise on the cross-examination and should have raised it, addressed it, and disposed of it. Fair enough. How does that sound in consequence? What difference does it make to the outcome then? Should it make any difference? Your learned friend says that the trial would be rendered unsafe, etc. You've heard him. What would you say, so that if we agree that that is a gap and that should have been addressed, but it was not, how would you say that should sound in consequence?
Yes, Your Honor, since this is not a hypothetical question,
This is not a hypothetical. No, it's not. This is a real question for you.
since the judge has very plainly said, in the context of her judgment, which evidence she accepts, why she rejected self-defense, and even mentioned that she's looked at every possible sequence of events and cannot find evidence to support this, which seems to be the version from which the appellant is laying his foundation. I would say that in any event, the trial judge would have come to the same conclusion.
So would you then categorize this, just to lead you a little bit, maybe not intentionally, that this, you would therefore put this as a technical error, not, and therefore the provisor would apply? How would you? I'm just trying for you to articulate how it sounds actually. So what do? We suppose we say, when in our analysis, judge alone, we think it should have been done. But what? What would you say? But what?
But given the conclusions that the judge did arise and
On the evidence.
on the evidence and the fact that she did, even though the court thinks she should have gone further, even though she did clearly state that this version of events was rejected by her, that there has been no miscarriage of justice.
No miscarriage. Therefore, the conviction should remain.
Yes,
Okay.
Good. Thank you.
obliged. Your Honor, I had made some notes when my learned friend was speaking, but I do not feel with the way that my submissions have gone that I need to respond to the different comments that he made. But I did want to touch on one issue, and that was that the appellant tried in his submissions to suggest that Chile was waiting for this accused, this appellant, to come to the bar. The evidence shows that there was an exchange of words between Chile and Mrs. Betancourt. Mrs. Betancourt then went on her phone and spoke to someone. She tried to involve at least one prosecution witness in what was happening, and that prosecution witness said to keep her out of it. 20 to 30 minutes after Mrs. Betancourt came off the phone, the appellant arrived at the restaurant. He made a sign to his mother. She then pointed to Castellanos, and he immediately walked to Castellanos. He drew his weapon and he fired shots. The evidence was indeed that earlier, Chile had been asked to leave. But what he said was, according to the evidence, that he was not going to go. He wanted to talk to Nevis. That is what the evidence says. He wanted to talk to Nevis. The fact that he had a machete under the table, he was using it to cut firewood that comes from one of the witnesses, and it was under the table. I don't think that it can be argued that those facts lead to a conclusion that he sat there waiting to harm Nevis with that machete below the table. What the evidence is that his mother was on the phone, he then came, she pointed the deceased out to him, and he went with his firearm. But I thought that the way in which it was being argued was to try to add that suggestion to the fact that the appellant was later harmed by Chile. But on the prosecution's case, he was the one who was acting in self-defense because he had been shot while sleeping.
As I understand the evidence, the machete belonged to the owner of the restaurant. Was that so?
Yes, he had been chopping firewood for her early on in the day with that machete.
And then after the incident occurred with the shooting, she took the machete and placed it behind some fireplace, refrigerator, hoping that that would have been the end of the shooting. Little did she know that that was beyond recall at that point. Anything further?
Unless there's anything further that I can assist the court with.
Yes, there's one thing I wanted to ask, please. On the notes, we come across in brackets at sometimes judge's notes or note. What does that mean?
When the recording is inaudible, the stenographer would ask the judge to assist by providing the notes, and so the transcript would be taken exactly from the judge's notes. But they are required to indicate the difference between the actual words and what the judge has.
So the poor
recorded.
judge still has to write?
The court still has to keep a record because the record of the judge herself is the official record. And it is done that way specifically for times like these when there's a failure of the machinery, there's still a record. Some judges type, some judges still write longhand, but the judge always keeps a record.
Okay, thank you very much.
Thank you.
Unless there's anything further,
No, thank you, Counsel. I think
obliged.
that's fine.
Thank you.
Thank you. Okay, Mr. Prasad, we're happy to hear you for 10 minutes in reply, if you wish to make a reply.
Thank you, Your Honors. I don't propose to say anything in reply, but other than to address the question that JCCJ Rajnath Lee had asked about whether research was done on the question of judge-alone trials and whether there's any learning on the question of the extent to which the judge must, in his or her reasons, reduce. And I have not been able to find anything. Judge-alone trials, I'm going to say, certainly this part, Trinidad, and things, fairly recent, but there have been many. In Trinidad, we've had probably at most 3 cases get to the appellate level, but I've not seen anything that has actually laid down criteria. I don't know if that argument has been made, but as I say, the context in which I had put it was dealing with what I say is a substantial jurisprudence in relation to magisterial appeals and in that context, but outside of that, I am not aware of any regional authority on that issue.
Yes.
Unless I could be of any further assistance, those are my submissions.
Thank you, sir.
Yes?
Thank you.
Yeah.
Well, thank you, Counsel. This was most interesting. And as usual, we are very pleased when you appear before us in person. We have the opportunity of also appearing before you in person. and we appreciate that very much. Naturally, we'll take some time to consider the arguments that you have put before us, and when we are ready with a decision, you will be notified accordingly. Madam Deputy Registrar, would you mind? Thank you. Closing the proceedings.